It's a crime that is almost impossible to comprehend. A woman abandons an infant by placing the child inside a backpack. The defendant, Bridget Adams, now stands before Judge Boyd, not for trial, but for sentencing. She appears polite, remorseful, and ready to accept her fate. The judge has a reputation for being firm but fair, often giving defendants a second chance to turn their lives around. But for a crime this shocking, will mercy even be on the table? What follows is a multi-year saga of second chances, stunning violations, and increasingly dramatic courtroom confrontations. Bridget Adams will be back in this courtroom not once, but twice more, each time with more excuses and higher stakes. This is the story of a defendant who was given every opportunity to succeed, and a judge whose patience is about to be pushed to its absolute limit.
All right, the court is going to call 2021 CR 8557A, State of Texas versus Bridget Adams. Could I have the parties announced for the record for the state?
Caitlin Wilkes for the state.
For the defense?
Hector Garza Jr. for the defense, Your Honor.
And are you Miss Adams?
Yes, ma'am, I am.
All right, and the court will note for the record that the defendant entered her plea by video as well. According to the plea bargain agreement, punishment is to be assessed at 2 years in the state jail facility. There's a $1,500 fine to be probated. The state is silent on the defendant's request for deferred adjudication. The state does recommend community supervision. State, you're remaining silent on the defendant's application. Mr. Garza, are you still requesting, or is your client still requesting to be placed on deferred adjudication?
The defense has just requested, and the defendant has confirmed, that she wants deferred adjudication. This is a critical legal concept to understand. It's not a get-out-of-jail-free card, but it's the next best thing. Essentially, the judge is putting the guilty verdict on hold. If Bridget successfully completes a long and difficult probation, in this case 5 years, the charge can be dismissed, and she avoids having a permanent felony conviction on her record. If she violates her probation, however, the judge can revoke the deal, find her guilty, and sentence her up to the maximum punishment of 2 years in a state jail facility. For a charge as serious as endangering a child, getting an offer of deferred adjudication is a massive olive branch from the court. The question is, will she take it seriously?
She is, Your Honor, and for the record, Judge, I have explained to my client the difference between regular and deferred. I have explained to her the positives as well as the big negatives of the deferred, which would come in case she violates and doesn't complete successfully. But she does wish to request deferred.
All right, so here's the thing, Ms. Adams. The state is requesting that if you were to be revoked, your underlying sentence would be 2 years. If you're placed on deferred adjudication and you're revoked, your your maximum sentence would still be 2 years. So I can give you deferred adjudication. The thing about deferred adjudication, it won't result in a conviction being on your record for this if you successfully complete it, but it's still going to show on your record. So are you still requesting deferred adjudication?
Yes, ma'am, I am.
Okay. So this is what the court will do. The court will place you on 5 years deferred adjudication. There's a $1,500 fine to be probated. And the court, of course, is finding there's sufficient evidence of your guilt, but deferring finding of guilt as
The judge's shock is palpable. You can hear it in her voice as she says, so much could have happened with placing a baby in a backpack. This isn't just a legal proceeding for her. It's a moment of human horror. Because of this, she's laying down one of the strictest conditions possible. Absolutely no unsupervised contact with any minor child. This isn't just about her own stepson. It applies to any child, anywhere, anytime. She even directs a warning at the defendant's fiancé, making it clear that if he leaves her alone with his 2-year-old son for even a minute, Bridget will be the one facing a motion to revoke her probation. This condition will hang over every single day of her 5-year sentence, a constant reminder of the trust she broke.
you've applied for deferred adjudication. And I see that another attorney, another judge took this plea. That was Judge Her. Do you have any children?
I have one stepson.
All right. And are you still involved in his life?
Yes, ma'am. Me and my fiance are still.
How old is the stepson?
He's 2 years old.
All right. Is Child Protective Services involved?
No, ma'am, not at all.
All right. So we're going to do parenting classes. No contact. with Trisha Hudgins, Hudgins. There's to be no unsupervised contact with any minor. So that means you're not allowed to babysit. You're not allowed to do anything of that nature. Do you understand?
Yes, ma'am. I completely understand.
So your fiance is not allowed to leave you alone with his child. You understand?
Yes, ma'am. Currently, we live with my sister, so I'm never left unsupervised with the child.
And you understand the reason for that, my request at that, correct? Because so much could have happened with placing a baby in a backpack,
Yes, ma'am.
especially a newborn, but any child in a backpack.
Yes, ma'am.
There's going to be CPS compliance if applicable. There's to be a MIC mouth evaluation out of custody. And that's to take place on December 20th. So you are to make sure you complete that and you report on December 20th for that appointment. Do you understand?
Yes, ma'am. Will I be getting the paperwork to know
Yes.
the address and stuff?
Yes, you
Yep.
will.
Thank you.
If you do not report for that appointment, then a warrant may be issued and a motion to revoke may be filed. Do you understand?
Yes, ma'am.
So when's the last time you used any type of drug? And when I say drug, that includes alcohol as well.
The night I was arrested, ma'am.
And how much alcohol or drugs were you using?
I consumed three beers, 24 ounces.
There's going to be the UA hotline upon release, field visits. And Rebecca, tell probation, I'm sorry for this, but I don't know who's in charge of that. The 2-year-old, 2-year-olds can't get on the phone and say, I'm being left, with people I shouldn't be left with. So it's going to be field visits 4 times per month, random.
Bridget Adams walked out of her first hearing with a golden opportunity, 5 years to prove herself and keep a felony off her record. The conditions were strict, but the path to a clean slate was clear. She thanked the judge and promised to be successful. But just a few months later, she's back in the same courtroom facing the same judge. The document in front of her is a motion to enter adjudication of guilt. This means the state believes she has already failed. Her incredible second chance was just handed to her, but how long did it actually last? The answer is shocking.
Proof of employment within 30 days of release, no employment as a home health care provider or with minors, or proof of SSI within 30 days. There is to be weekly Zoom reporting or in person until that evaluation is complete, Rebecca, and she's actually under the supervision of that. And we'll see if she's appropriate for the MIC unit. 200 hours of community service restitution. 40 of those hours would be waived if she provides proof of her COVID vaccination. And the state is asking for a deduction of 5 community service hours for each month the defendant stays on prescribed medication. And I'm okay with doing that.
This is a stunningly fast failure. The judge sentenced her on December 8th, ordering her to attend a mandatory mental health and substance abuse evaluation on December 20th. According to the state's motion, she simply didn't show up. She violated a key term of her probation in just 12 days. This is a colossal red flag for the court. Despite this immediate and blatant noncompliance, the judge is showing incredible restraint. Instead of revoking her probation on the spot and sending her to jail, she's agreeing to continue her on community supervision, merely ordering her to complete the evaluations while in custody. This is her third chance, and it's one she absolutely did not earn.
And so, Ms. Adams, is there anything else you need from the court in order to be successful?
Um, no, ma'am. No, ma'am. God bless y'all and thank y'all very much.
All right, and Miss Adams, I'm serious about the no unsupervised contact with any minor. So if there is something that pops up where your fiance says, hey, I'm just running to the convenience store, I don't feel like putting the baby in the car seat and doing A, B, and C, you need to tell him that is unacceptable for him to leave you alone, because otherwise you're going to end up with a motion to revoke. Do you understand?
Yes, ma'am. Most of the time I go to the store with them and the baby anyway.
Okay, so just remember that, and that's not just for that child, that's for any child.
Yes, ma'am.
All right, with that, we will close the record. Ms. Adams, good luck to you. Bridget Adams.
And here we are again. For the third time, Bridget Adams stands before the court on case number 8557A. This time, the allegations are far more serious than a single missed appointment. The new motion lists a string of violations, including failing to report to her probation officer for 3 consecutive months. The attorneys have worked out a deal, but after 2 prior appearances that ended in failure, the judge is no longer just supervising, she's investigating. The polite, agreeable facade we saw in the first hearing is about to crack under pressure as the full story of her time on probation comes to light and the judge's patience finally wears thin.
All right, the court is calling 2021 CR 8557A, State of Texas versus Bridget Adams. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
James Ishimoto for the defense.
And are you Bridget Adams?
Yes, ma'am, I am.
I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that document with your attorney? Did you understand it?
Yes, I did, Judge.
Are you the same Bridget Adams who was placed on deferred adjudication in 2021 CR 8557A for the offense of abandonment, endanger of child, criminal negligence on December 8, 2021 for a period of 5 years? Is that you?
Yes, ma'am, it is.
State?
Violated condition number 40 on or about the 20th day of December 2021 in Bexar County, Texas. The defendant, Bridget Adams, did then and there fail to attend MIC, Myoff, TCOOMI in violation of condition number 40.
How do you plead to that? True or not true?
True.
State?
We're waiving the other allegations.
Any objection?
No objection, Judge.
All right, Ms. Adams, did you understand by pleading true to violation of condition number 40, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am, I did.
Knowing that, do you still wish to plead true to violation of condition number 40?
Yes, ma'am, I do.
Court will find violation of condition number 40 true. Is there an agreement?
Yes, Your Honor.
Yes.
We ask that you find the violation true, that you continue the defendant on community supervision, and that she remain incarcerated while the MIC, Myoff, TCOOMI evaluations are completed, and then that the conditions of probation be amended to follow those recommendations from the evaluations.
So the court will follow your agreement, deny the motion, alter and amend conditions to include MIC, Myoff, and the Tacoma evaluation. That's to occur while the defendant is in custody, and the defendant is to follow all recommendations.
Appreciate you, Judge. I've had patience in my pocket this morning.
Oh, well, I'm glad, people, and you should take it out when you need it. Sometimes people will keep the patient in their pocket. I'm like, no, take it out as needed.
Yes, ma'am, I do. Believe me, I do.
But it's a beautiful day today. We have some rain, so that means that we're going to have beautiful flowers in May.
Hope I'm out to see them.
Oh, we shall see. All right, and Ms. Adams, I'm going to send you to a breakout room with probation and
The state and defense have come to an agreement, revoke her probation, find her guilty, and sentence her to 2 years, but with so much credit for time already served in jail and inpatient treatment that it would essentially be a time-served sentence, she would walk free. On paper, it seems like a clean resolution, but watch the judge's reaction closely. She doesn't just rubber stamp the agreement, she stops the proceedings to read the probation officer's case summary. This is a pivotal moment. The judge is signaling that she isn't satisfied with the tidy narrative presented by the lawyers. She wants the unfiltered story from the people who were actually supervising Bridget, and what she's about to read will change the entire direction of this hearing.
Probation is going to go over conditions with you. Can I get a file stamp? Motion to revoke. Court is calling 2021 CR 8557A, State of Texas versus Bridget Adams. Could I have parties announced for the record for the state?
Zach Dunn for the state, Your Honor.
Defense.
Joseph Uphelt.
And are you Bridget Adams?
Yes, ma'am.
Going to show you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that document with your attorney? Did you understand it?
Yes. Yes, sir.
I mean,
Yes,
did
ma'am,
you-
I'm sorry.
That's okay. Did you review it or no?
Yes, ma'am.
All right. Are you the same Bridget Adams who was placed on deferred adjudication in 2021 CR 557A for the offense of endangering a child on December 8th, 2021 for a period of 5 years? Is that you?
Yes, ma'am.
Now on the stand, Bridget Adams begins to craft her redemption narrative. She claims she's been clean for 8 months, she has a job waiting for her, and she's no longer with the outside influence who led her astray. Her attorney reinforces this story, presenting her as someone who, despite a stumble, has found her footing. This is her plea for mercy, an attempt to convince the judge that the person who absconded from a treatment dorm and ignored probation for months is gone, replaced by a new responsible woman who is ready to settle down. It's a compelling story designed to tug at the heartstrings and secure the lenient time served sentence. The problem is, the judge has heard stories like this before.
All right, state.
Your Honor. Violated condition number 5. In Bexar County, Texas, the defendant, Bridget Adams, did then and there fail to report to the supervision officer as directed for the months of June 2023, July 2023, and August 2023 in violation of condition number 5.
How do you plead to that? True or not true?
True.
And Your Honor, the state will waive and abandon the other conditions.
Any objection?
No objection, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will
This is a master class in judicial insight. As soon as Bridget mentions her mother's illness, hoping to garner sympathy, the judge cuts her off. "Don't play the illness card on me," she says, completely dismantling the defendant's strategy. In a brilliant reversal, the judge points out that it was Bridget's own behavior, her addiction, her probation violations, the constant worry that has been causing her mother stress and likely contributing to her illness. She turns a cynical plea for pity into a powerful moment of accountability, forcing the defendant to confront the real-world consequences of her actions on the very people she claims to care about. The judge sees right through the performance.
find violation of condition number 5 true. Is there a proposed agreement?
There is a proposed agreement, Your Honor.
And what are you requesting, state?
The proposal, Your Honor, would be revocation, adjudication of guilt, an affirmative finding, and essentially, if I have the days right that counsel had provided, it's 300 plus days of time served credit with potentially inpatient treatment, if that time would be counted, would almost equal the 2-year timeline for the state jail, Your Honor. So it's essentially revocation, adjudication of guilt, affirmative finding.
The judge has heard enough. She completely rejects the time-served deal negotiated by the attorneys. The leniency is over. She lays down a harsh ultimatum with only 2 choices. Option 1, she finds Bridget guilty, putting a permanent felony on her record, and sends her to a lockdown substance abuse facility called State ISF. Option 2, she revokes her, sentences her to 2 years in state jail, and explicitly denies her credit for the hundreds of days she spent in a treatment program she absconded from. Notice the power shift. The easy way out is gone. The judge is now forcing a true consequence, making Bridget choose between a felony conviction with mandatory treatment or hard time.
And essentially a time served, given the time that this individual has spent. That's the proposed agreement, if I'm stating everything correctly, counsel.
That's correct, Your Honor, and if I
An
may,
affirmative finding,
This is an endangering your
but that wasn't requested as a part of the plea bargain agreement.
Okay,
And I didn't find an affirmative finding of family violence beforehand. If you all are agreement to that there be an affirmative finding of family violence, of course, I will go with that.
we would prefer not, Judge.
that's absolutely fine. Your Honor. We're happy to waive an
All right.
And I wasn't part of the plea originally, Judge. I was not aware that that was not part of it. However, I think we're in agreement that it will not be a part of this.
That goes for the
agreed
state, Your
rec.
Honor. Absolutely.
Okay.
If I may, Your Honor,
Yes.
my information is that Ms. Adams has 336 actual days jail credit.
Mhm.
Did complete SafeP successfully at 286 days at SafeP, and we're asking for that total of 622 days being for her to be given credit for the total of 622 that she has been in custody in one way, shape, form, or other, and to go along with our agreed recommendation and have this as a JSAT.
All right. So they're saying that I'm reading, any objection to the court reading the court reporter, I'm sorry, the probation officer case review?
The court summary, Judge, no.
Okay. So it says here that she left the dorm and never returned. What's that about? Do you want to address that?
Yes.
Just
ma'am.
1 second. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
My name is Bridget Adams, ma'am.
All right, so why did you leave the dorm?
Yes, ma'am. At the time, I was in my addiction. And I left and I went and got high. But may I say, ma'am, as of today, I have been clean of 8 months and I also have a job waiting for me and I will be staying with my mother and father if I get released.
The reason for the leaving of the dorm, Your Honor, was an outside influence with a person that she was involved with, who she is no longer involved with, is my understanding. It's been reported to me by Ms. Adams. And her successful sober time period of 8 months, as she reports to me, is because she is no longer with that person and does not associate with that person. That, and with the support of her mother, is where she is relying upon to remain sober. She has not picked up any new offenses either. And she does say she does have a job waiting for her through a friend of hers who is a manager at Whataburger.
She hasn't really been successful on probation. And her sobriety for the 8 months, is that because she was in custody?
No, ma'am.
No, the time in custody was spent prior to her being picked up on this MTR, Judge, is my understanding.
Okay, so I don't know if she was clean and sober or not. We're just going by what she's saying.
If I may, Judge.
Sure.
My mother can attest to it. If need be, I have not touched methamphetamines or anything in 8 months. I actually am engaged and I am trying to settle down and I'm trying to do better. Yes, I know I have not been very, what's the word?
Compliant.
Compliant. Yes, thank you. I know I haven't been very compliant and yes, I know my actions do not show that I've been compliant and I very much apologize because you have been gracious with me. But I am asking because I have been sober and I do have a job waiting for me and I do have a mother that is waiting for me to come home and she is very ill right now.
All right, so here's the thing. I always tell people, don't play the illness card on me with the parents. And the reason why I say that is
In a stunning last-minute revelation, Bridget discloses a dark and tragic detail. The bad influence she repeatedly blamed for her downfall, the ex-boyfriend she was with when she relapsed, is dead. He committed suicide just a few months prior. This is a bombshell dropped in a final desperate attempt to explain her actions and perhaps garner some sympathy from the judge. It immediately complicates her entire narrative. While a tragic event, the timing of this reveal feels calculated. Is this a genuine piece of her story, Or is she using this person's tragedy as one final excuse for her own repeated failures to comply with the court's orders?
Because one, she doesn't need stress in her life, and you're not doing well on probation has caused her stress and contributed to exacerbating her illness. You understand?
Yes, ma'am.
So when you say you are engaged now, what does that mean?
I have a fiance at home and he's also working and he's been helping me stay sober. He's been sober for 5 years now, ma'am.
Okay. And did anybody know this?
State was unaware.
I'm not inclined to just let her skate on probation and get 2 years and have that be a judgment satisfied. So here are your choices. I'm giving you two choices.
Okay.
One, I can find you guilty and place you on regular probation. Or two, I'll give you the 2 years, but you're not getting credit for inpatient treatment time. So which do you prefer? And if I give you probation, according to their recommendation, you're going to state ISF. So I can revoke you, sentence you to 2 years. You're not getting credit for your inpatient time. You get credit for your jail time. Or I can place you on regular probation, which would be a felony conviction, and you're going to state ISF. Which do you prefer?
Maybe ask them how to visit judge so I can discuss with her.
Yes.
Yeah.
Ms. Adams, have you made up your mind?
Yes, ma'am.
And what are you requesting?
Yeah. May I address the court, Judge?
Yes.
What Ms. Adams is requesting is to follow the first recommendation in the court summary, which would be to actually continue her on deferred, go to state ISF. She is in visiting with her. She wants to assure the court that she knows that she did not do everything she was supposed to the way she was supposed to. She did successfully complete safety though. And but for this other bad influence who she no longer associates with, she would have been able to successfully continue on her deferred journey. She is wants the court to know that she will be moving in and living with her mother and father. They are still together, Judge. And she does have this job waiting for her once she is released from custody. And we understand with state ISF, it'll probably be another 4 months down the road or so, because there's a waiting period plus the 90 days on that state ISF cognitive track. I apologize.
Yes, no, I'm not inclined to let her continue on deferred because she was sent to felony drug court. And people say I should not explain, but I like to explain so you'll know where I'm coming from. And I'm just not saying no just to be saying no.
Yes.
All right. So you were sent to felony drug court. You left the dorm without permission. You absconded from felony drug court, and felony drug court was continuing to try to get in contact with you to get you to come in. You did not. And you had a prior motion to revoke with this court. So this is not your first motion to revoke. So I'm not going to continue on deferred. So it's either guilty and you will be placed on probation, or either it's guilty and you will be given the 2 years, but not credit for inpatient time.
What we discussed previously. So
Yeah.
you said you wanted the ISF.
ISF, ma'am.
All right. Are you waiving your right to appeal?
Yes.
All right. The court then will find you guilty. The court will sentence you to 2 years in the state jail facility, suspended and probated for 5 years. I don't know if she's going to qualify for state ISF probation because last time there was an issue with mental health.
If I read it correctly, there's something with the DDRF that she did not qualify for DDRF.
All right.
That's my epilepsy.
All right. I'll alter them in conditions to include state ISF or felony drug court. And she's to remain in custody. There's going to be regular reporting by Zoom or in person. Random, regular UAs. Field visits. 1 time per month for 4 months. And then at probation's discretion, proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors. And there's to be no unsupervised contact with minors. I'm not gonna ask her to complete parenting classes again if she's already completed it. I'm not gonna ask her to do community service hours if she's already completed it. But whatever she has not completed, when she was on deferred adjudication, she'll need to complete it probation. And then, are you receiving SSI? I have a note here where previously I said proof of SSI.
I was working on fighting for it, ma'am.
Okay. All right, so there's gonna be, you're gonna have to be employed, you understand?
Yes, ma'am.
All right, there's gonna be 200 hours of community service restitution. Okay.
Yeah.
Anything else probation? Is there anything else you need from the court in order to be successful?
Just support.
Okay,
You know,
all
I'm
right.
trying to stay sober. I'm trying to do the right thing this time. So, and like I said, I've been 8 months sober and I just want to continue because the person that my attorney, Mr. John, was talking about, he is actually recently deceased. He committed suicide. So I
Is that your fiance or someone else?
he was my boyfriend at the time, the influencer.
Mhm.
He just recently committed suicide and he passed away on January 21st. So I have no contact.
All right, so here's the thing. If there's an issue, you don't just abscond, you're on probation.
Yes,
Right. If anything were to happen and you were to get another motion to revoke, you're looking at potentially 2 years at the state jail facility. And I'm sure your attorney told you state jail time is day for day time. You understand?
Yes, ma'am.
If there is something and you feel like probation is not addressing it, you can always come back to the court. And when felony drug court comes to interview you, you need to apologize to them and ask to be placed back in their program. That's a great program. Do you understand?
Yes, ma'am.
All right, we can go off the record. Here's what I understand. Usually people will gravitate towards people who are in treatment. Felony drug court will tell you that's not a good idea.
After a years-long saga, the final gavel falls. Bridget Adams started this journey with an incredible opportunity to have a felony charge for abandoning a baby in a backpack erased from her record. But after immediate violations, absconding from treatment, and multiple hearings, the judge's patience finally ran out. The final outcome, her deferred adjudication is revoked. She is now a convicted felon. Instead of jail, the judge sentences her to 5 more years of probation, but with the condition that she first be sent to a secure inpatient substance abuse facility. The cycle of chances is over, replaced with a final, stark ultimatum. What did you think of the judge's decision? Was this the right sentence after so many failures? Let us know in the comments and subscribe for more in-depth courtroom breakdowns.